Hello, everyone. Thank you for joining us for another monthly immigration litigation roundtable hosted by the MICA Center Immigration Impact Lab. Very honored to be here today with my colleagues, Sam Shea and Laura Lorenzo, who will be leading the training today. We'll be speaking about top strategies for litigating in immigration court and the BIA in preparation for Trump 2.0. I know that's on everyone's minds. As always, we want these roundtables to be a space where you all can share strategies with each other. So please do feel free to add in the chat or come off mute anytime if you want to share something that might help a colleague, or if you have a question, strategy question about anything. And we will leave time at the end for more group discussion, as well as take some throughout. So to get started, a little bit about the MICA Center for Immigrant Rights. Many of you know us formerly as CARE Coalition. We changed our name last summer in honor of our 25th anniversary, and to reflect that we're no longer operating in just the capital area. We have clients really around the country now, and particularly throughout the East Coast. And our focus is on defending one another. We engage in unwavering legal defense and strategic litigation for immigrant children and adults facing detention and deportation. We believe everyone deserves access to due process and legal representation. And we work every day to make that a reality with our teams. The Immigration Impact Lab is where we house our impact litigation work, a lot of PFR appeals, habeas petitions, some class action work. And we work really closely with our direct services teams, which are do the majority of work at MICA Center. Laura is here representing. She's the first time we're having someone from our detained adult program co-present, which they are really expert litigators. So I'm excited she'll be able to share some tips from as we think about the IJ level. And sort of our theory of change, we do a lot of work that starts off at the IJ level, and we're actually increasingly working on the IJ level, building the record with the assumption a lot more cases will be going up on appeal in the next 4 years. So I will turn over to Sam to kick us off.
Thanks so much, Adina, and thanks so much for joining us all. So understandably, a lot of folks are concerned about what's to come with the next Trump administration. So we're having this training that's basically like hodgepodge, kitchen sink list of tips for how to litigate at the IJ and BIA appeal level to really set yourself up for success. So first, we'll be talking about IJ level litigation, then we'll be talking about BIA and appeals, and finally, you're going to have some time set aside for some group strategy discussion. We'd love to hear from you all as to what you think is going to come and how you're prepping for these changes. Next slide, please. So as folks can anticipate, we're going to see a lot more appeals under Trump 2.0. DHS is already appealing a lot of, I would say most IJ grants. It's probably going to be almost all under Trump 2.0. And so it's really important to really preserve the record, anticipate cases going up to appeal if you win, anticipate, unfortunately, more losses at the IJ and BIA level. Really set your sights on preparing for litigation at the BIA and even PFR level. And you can do that by just making sure that your evidence, your arguments are the best that they can be. And we're going to walk through some tips for how to help you do that. Now, before going into immigration court litigation, it's really hard to litigate well when you don't have access to the entire immigration court file. So I want to remind folks of this procedure from EOR for requesting ROPs for cases that are not on ECAS. This is a mechanism that's outside of FOIA, and what you can do is you can request the ROP from the immigration court if your case is before immigration court, with the BIA if your case is on appeal. Now, we don't unfortunately know if this procedure is going to stick along. We certainly hope that it does. So recommend folks requesting the ROP sooner rather than later if it makes sense for you to do so. For cases that have been closed for a while, unfortunately, we've heard that this procedure is not available. I think those ROPs are subject to FOIA still. And Amica Center has a helpful practice advisory laying out these steps as to how to take advantage of this ROP request procedure. It's also laid out in the Immigration Court and BIA practice manual.
And quick shout out I'll give to Sam. She's very modest, but she led national advocacy to help secure these new policies along with our partners. So it's a very recent policy, and like she said, we will see how if it continues. The implementation's already been shaky. Separate note, if you've had implementation challenges with this, let us know because we can help use that to advocate.
Thanks, Adina. Yeah, it is an issue that we continue advocacy on with our partners. And with that, we'll jump into litigating at the immigration court level.
All right. Thank you, Sam. One thing I will say about the EOIR FOIA, I just submitted one before logging in here today. In my experience so far, it's been easy. You only need an EOIR 59 form signed by your client to prove consent and prove identity. It's been pretty expedited to by surprise, but hopefully it stays that way. So let's talk about tips for preserving issues for appeal. As many of the things that I will say today will seem obvious, but they are not that obvious when you are in the trenches. Why is it important? Because any issue the respondent wants the BIA or the circuit court to review on appeal, it must be raised before the IJ. Failure to raise an issue before the IJ generally results in being unable to argue that issue later. So first, we need to pursue each relief, each mean of relief available. We need to articulate alternative viable PSGs if we are in the realms of asylum or withholding of removal. And we need to preserve arguments challenging bad precedent. To do this, and in the words of the Fourth Circuit in Portillo Flores v. Garland, you don't need to conjure up magic words. There's no magic here. Just do your best to preserve and to hit the arguments so that they are preserved later for an appeal. The Third Circuit says pretty much the same. It lends us a hand here saying, make an effort, just make an effort, however insufficient to place the board on notice that something is coming before them, that an issue is being raised. This is Nkomo v. Attorney General in the Third Circuit. It's from a case from 2021. As we say there, the minimal effort, footnotes are enough. So just drop a footnote, but put everything in the record. Next slide, please. Okay, overall evidence pointers. This again seems obvious, but it's not. Don't forget that every case is different. And why do I say that? Let's talk about a Salvadoran case. We may see a case say, oh, yes, it's a El Salvador case, a state of exception case. I have all the evidence for SOE cases, state of exception cases. It doesn't work that way. Every case is very different. So you need to adapt the evidence to your particular case. You need to present precise, compelling evidence at every single stage of the process. But again, I would say focus on quality, don't focus on quantity. And this is especially important lately because I've seen more and more that IJs and many courts are now imposing page limits on country conditions evidence. I have a lot to say about that, but this is not the place. But in this case, it is important that you take the following steps. First, file a motion to extend the page limit. Don't abide by that. It's usually at 150 pages that they impose. Just file a motion to extend the page limit. In that motion, say, why is it important to do so? I can come up with many reasons why it's important, because it's the applicant's burden of proof. And as their advocate, we need to do our very best to present all the evidence. It is necessary in the case to ensure that the applicant has a reasonable opportunity to present evidence on their own behalf. Because it may be a fact-specific, the case would call for a fact-specific inquiry that requires significant background evidence to be presented, or because the case heavily relies on country conditions evidence, and so on. I mean, there are many ways, but the legal arguments, I would put them first. It's our burden of proof, and they need a reasonable opportunity to present evidence on their own behalf. After that, usually when you present a motion, at least this has been my experience, when you present a motion to extend the page limit, it is approved. Then I would do an act of good faith and my due diligence in making it easy for the judge to find relevant information. How do I do that? I elaborate a detailed table of contents with relevant quotes. I include excerpts instead of including like a full report on, whatever the environmental conditions of the country that don't matter in that particular case. I would just remove that and just include the relevant pages and links to the full article or report if that's what we're quoting. Another thing, there are some things that where the IJ can take administrative notice. For example, the human rights report from the State Department. So I would ask for that, so that I don't have to use up all my room just to take to include evidence that could be included that way. If you're unable to get something, also I would say include an explanation of why this evidence is missing. I've encountered cases here where corroboration was the whole deal, and it has been taken to appeal because of corroboration. You could do that in different ways. You can include it in your client's declaration or during their testimony. You can ask, why is this not included? If it's a different witness, and if possible, try to have a paralegal or someone else talk to that witness. Why? Because you may be in the position where you have to request that person to write an affidavit saying, I did do the investigation, I called this witness told me that they filed, they have a case in court and they don't want to testify. And that's enough. But be mindful of that, because it can come up, and it does come up. Then make sure that you tailor evidence towards anticipated changes in the law with the new administration. This will require, and we know how this goes, staying up to date with what's going on, being on our phones every Friday. But it's important to know what's going on and how we can adapt our evidence. Next slide, please.
I have a quick point. Thanks so much, yeah. Laura. So on the tailoring evidence towards anticipated changes in law, I think it's hard to know exactly what's to come with Trump 2.0, but we can kind of guess. I mean, the first time around, you had LEA, AB, and thankfully those aren't, well, LEA 2 and AB 1 and 2 are no longer good law, but I think it's very likely that that kind of precedent is going to come back. So if, for example, if you're raising like a family-based PSG, and it's like nuclear family, if you have some kind of evidence that shows that this family is like really famous, even if that's not required under current precedent, get that in the record, because you actually might need it later should these standards become heightened under the next Trump administration.
Thank you, Sam. So creating specific declarations. You want to make sure that there is evidence to support every required element of your claim, right? So make sure that facts are tied to each element of the claims, especially on nexus. You want to include statements from persecutor, timing of threats and attacks, included intensification, persecutors' personal animus towards the group or targeting as means to an end, evidence that other individuals in the group were also targeted while others outside of the group were not. Again, let's think about a Salvadoran case. I'm thinking of this because this is what comes up the most, at least in my practice. Um, you have to think. You need the macro view of your case. Okay, what's the main argument? Well, if my client ends up in prison, he or she will be tortured. Perfect. How will your client end up in prison? How will he get detained? Does he have tattoos? Was he flagged as a gang member? Does he have a relevant criminal record that will be shared through the information sharing system? All these things you need to have evidence on. It's not something that you just can come up and make an argument about it if you don't have evidence backing it up. So that's why I'm saying, and I said before, every case is very different. So why? And here I will give you the example. I have a client that has alleged gang membership. He's very fully tattooed. He has a very big and important criminal record, and he has been flagged as a gang member, not alleged, gang member. Then I have another client who has no tattoos, no criminal record, nothing. So both are Salvadoran, both are claims under the state of exception, but how am I going to prove that the one that doesn't look like a gang member, has no crime, how am I going to get him to that point where he will be in prison? And how will I get my other client who has gang ties and significant crime, how will I get there in prison where he will be tortured? So it's different, and you need to think all the way through and every step of your claim and prove it. Next slide, please. So again, the country conditions should be tailored to claims. They should substantiate social distinction for entire PSG, not just part of it. Same with country conditions on likelihood of persecution or torture. And this is what I was saying before. Sometimes, and this is very difficult, sometimes you have to screen your evidence and make sure that it's not contradicting in itself. I've seen some files where the evidence is contradictory and gives way for making a finding of fact that we don't want to be made. So you have to read your evidence, not just the headlines, and you have to highlight the relevant parts, but also be mindful of what negative portions are there that could damage your claim. Sometimes there's none, right? Sometimes there's nothing you can do. All you will find is that piece of evidence that has contradictory claims. And this is where it will take me to the next slide and to the incorporation of expert testimony. Expert testimony is especially key for niche or rare claims, or those claims where the evidence doesn't get you to where you want. I am currently working on a Jamaican case for a person of the LGBTQ community. Jamaica is it's a country that it's very hostile to LGBTQ persons. However, the articles that you find out there do not get us there. The government, they are doing their job. The government is really trying to, and that doesn't get us anywhere in the claim. So this is where I need to hire an expert. And again, hiring an expert is not just hiring the expert. You need to guide the expert. The expert is not an attorney. The expert doesn't know what we need to prove. So you really need to work with the expert and explain what needs to be proven and how. You will need to have at least a couple of phone calls with that expert and explain what you're trying to prove and ask, do you think this is a viable theory for my case? Do you think there are other theories? And work with the expert. You also want to, if budget allows, you will want to have that expert testify. Some IJs seem to incorporate the expert report into evidence, but then they attack it during their decision. And that has happened many times. So you will want to have that expert on the stand and give the IJ the opportunity to ask their questions if they have questions. And you will want also DHS to be able to cross them in case it's needed. Otherwise, you may have a problem later. So this is the end of my part of the presentation, but if there's one takeaway that I want to have here is that right now, at least most of my cases are being appealed. So I prep my clients and I tell them, listen, it is more likely than not that we will either lose and then we will have to appeal, or we'll get a grant, but the grant will be appealed. And that's the posture where we are all the time. And then it's remanded and then it's appealed again, and that's where we are. So you need to be very, very mindful in strengthening that record. I would say when you go to the merits, just work on building that record. Just don't even think of winning. Think of that appeal. Thank you very much.
Thanks so much, Laura. I was kind of curious about expert testimony. What percentage of cases would you say you hire an expert, and like how often do you go like back and forth with the expert on like their declaration?
That's a very good question. Right now, I hire experts every time I could. The cases where I wasn't able to hire an expert was because there was no expert available for that specific country. But otherwise, I try to have an expert available. I have my favorite experts. I've worked with experts enough that I have my favorite experts, and they already know the cases, what I want them to prove. But at least with these experts, these experts that are working constantly with me, at least one phone call we do have. If it's new experts right now on a case that I'm working on Jamaica, maybe 2 or 3 calls and review the report to make sure that they are including everything we want.
Okay, thanks so much. And turning to our last slide on immigration court litigation, I do see we have a question from Alice. Alice, did you want to go ahead and ask?
Yeah. Hi. Thank you all so much for this presentation. I was just curious as to whether you had any tips, or whether, there might be some pointers forthcoming on I think we will see again like expert preparation coming under attack, and like experts being attacked for bias. So whether there's anything y'all are doing in kind of anticipation of that, so that people don't shy away from using experts, who might have great expertise but could be attacked on those grounds, and sort of some tips for how to have those conversations with them in a way that walks that line, right, of not coaching them, but also making sure that the points are hit that we want to address.
I've seen that recently in one of our cases. It wasn't one of the cases that I was litigating, but a colleague of mine, and the expert's credentials were put into question. Not the credentials, it was his bias. Usually the way I prep is I try to ask them, have you ever testified for the government? Yes or no. I try to ask the questions that they would have been asked. They would be asked if they were on the stand for the voir dire. I would ask them, have you ever testified for the government? No. Why not? And they would tell you if they say something because I hate the government, or I don't know, then you want to be careful. I would also do some research into what kind of articles they have published, right? are there more objective articles, or are there more articles against a certain political stance? Or, I would try to do that research in advance before putting the expert on the stand. Sometimes you have to make the call, and even when it's not about bias, but you've heard the expert testify and it's a bad expert, it's a bad testimony, because they don't like providing testimony. They're not good at that. So sometimes it's a tough call that you have to make. And sometimes you just can have the report and have it just admitted into evidence and forget about the testimony. Sometimes it's strategy too, if there's no other expert available, but they could write a good report, and it could go under the radar and be admitted into evidence. Maybe I would not present that expert, but otherwise, yes, I would. Otherwise, I would do some research and see if there are options.
I'll just add too, I mean, be strategic about who you pick. Think about what the government would go after. We saw some cases in Trump 1.0 where DHS questioned the credibility of experts if they were particularly left-leaning, and then had sort of a easy target, like maybe they hadn't actually been to the country in several years, right? I mean, at the time it was like the pandemic, so that was what can you do about that? But yeah, like how recently have they been? How recently have they written academic articles about the place? Like, you don't want someone who was in Ethiopia 20 years ago and is purporting to be an expert, on what's going on today.
Great, thanks, Laura and Adina. Our final tip on immigration court litigation is making alternative arguments. So that goes for alternative claims for relief. For example, if you're putting forth the PSG for asylum or withholding, consider if there's a potential political opinion claim, and also put forth your best foot on CAT relief. I know everyone always does end up seeking CAT relief when they seek asylum and or withholding, but it's often treated as a throwaway claim. For example, if you have like 2 sentences in your brief about CAT, it doesn't look like you believe in that claim. The IJ is very unlikely to believe in your claim. And here at Amica, our direct rep attorneys, including Laura, have been actually pretty successful in getting CAT for our clients who are often DCAT only. And so, especially if you're in a situation where you have questions about nexus or a specific ground for asylum or withholding, really put forward that CAT claim and try to make it look like you at least believe in it and brief it well and have that evidence in there. Second tip for arguing in the alternative is addressing bad precedent. So when you have bad precedent that comes out, you want to basically do like a cascading alternative argument. You can argue that first, the case applies narrowly, that the bad language is dicta, shouldn't be applied in your case, or is distinguishable. You can also argue that the case is wrong and should be overruled. Now, I will say at the immigration court level, the IJ is not going to be able to do that for you, even if they want to. So that's just more of like a really fast footnote, preserving the record. Alternatively, argue that the case should not be applied retroactively if the case came out after your client entered the US or after they entered into removal proceedings. And finally, you really want to push that even if the precedent applies, you still win. You're still able to make the required showing under that case. Next slide.
Thanks, Sam. And I'll throw out to when ARCG was knocked down in the AB case, the gender-based particular social group, we went for CAT for a lot of those claims and did win some of those. So just emphasizing that point, don't forget about CAT.
Great, turning to our tips for litigating at the BIA. First, tips have to do with just really preparing, taking the necessary steps before you sit down and start writing that brief. So as I discussed before, you're going to want to make sure that you request the ROP to ensure that you know what's in the record if your case is not an ECAS case. Even if you're a counsel below, always good to request it. Make sure that everything you thought was submitted is actually in there. don't let DHS cite to something that you didn't know was in there that's going to hurt your case. Biggest and most helpful tip that I give everyone who's litigating at the BIA, you really need to read the IJ decision over and over again, especially if it's pretty long and has a lot of different rulings. And you need to outline that decision. You need to make sure that you're accounting for what the IJ says on every single element, whether they rule for or against you on each element, and what their reasoning is for ruling that way. This is going to ensure that you're able to, that you argue all the arguments that you need to if you are appealing the IJ's denial, and also vice versa if you won below and DHS is appealing. I've seen so many cases that's really unfortunate. The BIA brief does not account for a certain bases the IJ denied relief on. And when this happens, it's really easy for the BIA to dispose of that case. All they have to do is say, we uphold based on what the IJ said on this basis. And it's quite frankly really awful to see, and just a huge waste of the attorney's time, and also just brings up a lot of concerns for the client for diligent representation. Now, I know that sometimes these IJ decisions are kind of convoluted. You don't really know exactly what the IJ is saying. Are they ruling on a certain element, or are they ruling on another element? Consider how you can use this to your advantage, and you want to argue the alternative. So if it's better for you that the IJ did not address something, argue that. But then alternatively, even if the IJ did address it, that ruling is wrong. And so you'll take your outline of the IJ decision, turn it into your BIA brief outline. And you also really want to consider what remedy makes sense for your case. Now, if the IJ denies relief without getting to all the elements of a claim, you can't ask the BIA to grant your client relief. You're going to have to ask for remand. But even in asking for remand, you can ask for certain things on remand. For example, do you want to submit additional evidence on remand? Always worth asking, though the BIA may not give you what you want. You also really want to make sure that you're knowledgeable as to the standards of review at the BIA. Knowing which issues are issues of fact, which issues are legal questions, which issues are mixed questions, and the corresponding standards of review for each kind of issue. Now, I would say most of the time, the standard of review, or oftentimes the standard review, is not in your favor. When that's the case, there's no point in emphasizing, for example, if you lost below on a factual issue, how deferential clear error is. But in the rare cases where the standard of review is in your favor, you can certainly emphasize that and really weave that into your arguments on appeal. And for situations where maybe it's not clear what the standard of review is, you should take that opportunity, argue for the more favorable standard of review, give it a shot, see what the BIA says.
Sam, can you speak a little bit about credibility in appeal?
Sure. I mean, it's unfortunately really, really hard to get an adverse credibility ruling overturned. I mean, there is case law saying that adverse credibility doesn't mean that someone is per se ineligible for relief. The IJ still has to consider the independent evidence, but it's extremely rare for the IJ to have an adverse credibility ruling and then have that person granted relief. But Laura, I'd actually love to hear more from you about like adverse credibility issues that you've dealt with in litigating at the immigration court or on appeal.
So fortunately, I haven't had that come up on appeal. But yes, it's difficult. It's difficult to overcome a finding of credibility unless it's something extremely egregious that but and you need to make a good argument of why it's so egregious that it warrants remand or a different finding. But I've been lucky. I did have to address it in written closings before, and as long as it comes out during the hearing, and again, this is about preserving the record, as long as it comes out during the hearing, and you think that you need to address it in your closing, you need to address it, I think do it, go for it. Don't just leave it hanging there, because if there's any contradiction that may raise that question, it's better to address it before and set the record straight as to why it was just like, I don't know, if it's a person with mental health issues and they don't remember the dates correctly, I think you should address that in your closing before it becomes a bigger deal later, and you struggle to defend it before the BIA.
And I will say that if you're able, certain circuits, I think, have additional procedural requirements. I think this is the minority. Like, if the IJ has questions about credibility, they have to like point out inconsistencies and allow the person to explain or correct. I believe that's a minority position. But if you're able to point to something where that shows like that the IJ didn't follow certain precedent and making the adverse credibility determination, that's a legal error. And actually that's going to be really helpful, much more helpful than if you just disagree with the overall credibility determination by the IJ.
And I remember when this issue came up a lot more in Trump 1.0 with IJs going rogue and just finding folks not credible in order to shut down the cases. Our attorneys would often get into the record basically complaints about what the IJ was doing. So, for example, like I'm noting for the record that the judge is speaking like rudely to my client or not giving him an opportunity to answer the question. There's an issue with the interpreter, like anything you get in the record that can help you try to fight that credibility determination is helpful.
Yeah, that is a great observation, Adina. And when we try to preserve the record, and there are a lot of things that we see that are happening that are not captured by the recording and will not be in the transcript later. So anything as to tones, demeanors, as much as possible, try to put it into words so that it is included in the record, because that's the way you can build a strong record. If you just let it pass, and it will be very hard for you to overcome that. So try to put into words everything that you see is going on and that you perceive it's not right.
Yeah, another just tangible example of that. Let's say the judge is saying he's not credible because the client won't look him in the eye or something like that. You could say in the record, I observe for the record my client is having a panic attack right now and shaking uncontrollably and like can't speak, something like that to just really paint the picture. I see we're getting some questions in the chat. Is there anything y'all wanted to add on that?
I don't have anything to add on credibility. Laura, do you have any responses?
I do not. When I've seen here, I'm seeing a psych eval about it for addressing credibility. One of the things that sometimes happen, and I've seen this happening in court, was the IJ, after we submitted a psych eval. It was for a case. It was a case about pornography, child pornography. It was the underlying crime, and we hired an expert. The expert gave her report. The expert took the stand and testified towards that. And then the IJ started talking, well, but you never mentioned malingering. Why did not you mention malingering? And the expert explained that when you do those assessments about sexual recidivism, they do not assess malingering on its own just because it's included. Again, I'm not a mental health expert, so I put it in layperson's terms. But the IJ was not persuaded with what the expert had said and said, well, the expert did not assess malingering, so therefore the client may not be credible. So it was a very long shot, and what I doubled down saying, well, no, that's not what the expert said. The expert said that this is not the methodology for this type of assessments. So sometimes with the psych eval, you have to make sure also, for example, that malingering. Why are they not addressing malingering? Are they? And if they are not, to explain why they are not. I think that's important, and that goes towards credibility.
Great, thanks. Anything else either of you want to say on the clear error review and why we really need to get the facts in the record for that? Okay, moving on to the next slide.
I don't have too much to add. Yeah, I think it's
Yeah.
just pretty deferential. So you want to really bolster the record. Great. Yeah, so when your case is on appeal for the BIA, there's inevitably going to come a time when, especially under Trump 2.0, there's going to be bad intervening precedent. So it's super important to be organized, as in keep tabs on your cases. Just because your case is pending before the BIA and the briefing has been done for a long time, unfortunately does not mean you can just forget about it. You should be organized and keep note, have some kind of system that tracks for your pending cases what the main issues are, what the claims are. You also need to stay on top of new precedent. The BIA is not going to let you know when a new bad case comes out that it's going to rely on to uphold denial or to deny your client relief. It's on you to affirmatively think of that and brief the issue. So as discussed for immigration court practice with bad precedent, you want to do these arguments in the alternative. Where it's a bad BIA decision, the BIA does have authority to overrule its prior precedent. Now it's probably not going to, especially if that case just came out, but you really need to preserve that argument, especially at this posture, so that it could be raised at the circuit court level in a PFR. Now, if briefing has been closed for your case, what's the right thing to do when precedent comes out after briefing? Whether that's good or bad precedent, the BIA practice manual has two different options at chapter 4.6G, supplemental briefs. You can file first option is filing like a notice of new authority, where you cite the new authority, but the BIA is very strict. It does not let you include legal arguments. So you can summarize the case, but you're not supposed to talk about how it should be applied or should not be applied to your case. Second option is moving to file a supplemental brief. That in those kinds of filings, you can make legal arguments, but you have to seek leave from the BIA. Now, if the precedent is bad, you do not want to just file the notice and not include any arguments. Same thing if it's good. So highly encourage folks to take advantage of the second option, moving for leave, filing that supplemental brief, talking about how the BIA should treat that new authority.
And Sam, do you recommend filing the motion for the supplemental briefing along with the already briefed brief?
Yes, I think you have to.
Yeah.
And before turning to discussion, I do want to remind folks or make folks aware that the Supreme Court has granted cert in a case called Riley. And this case has to do with, first, whether the 30-day PFR deadline is jurisdictional or a claims processing rule. And second, when a PFR has to be filed for a FARO or reinstatement case to be timely. Currently, there's really bad case law in the Second and Fourth Circuits that have ruled that even if someone seeks withholding only and is in withholding only proceedings, they still have to file that PFR within 30 days of the FARO or reinstatement order. And so what this means is that regardless of which circuit you're in, given that SCOTUS has taken the issue up, we hope SCOTUS goes the right way, but if SCOTUS goes the wrong way, everyone has to file the PFR within 30 days of the reinstatement order or FARO. So encourage folks to file what's called a protective PFR in the middle of proceedings, even if you don't know whether your client's going to be granted relief, if your client even wants judicial review later. And that's for the purpose of preserving potential judicial review in the future. And we do have pro se materials and also counsel materials for the Third and Fourth Circuits, protected PFR templates, as well as motions for a stay. I will say that even though Riley has to do with FARO, and the circuit courts that have decided the issue have dealt with reinstatement cases, there's also the concern that this kind of a bad holding could extend to INA 240 proceedings, where the BIA upholds removability. For example, they uphold denial of asylum or cancellation, but then they remand for further proceedings, for example, on CAT, withholding, or VD. And that's a situation where arguably there is a final removal order, given that CAT, withholding, and VD don't affect the final removal order. And so if folks want to be even more cautious, you can file a protected PFR within 30 days of that BIA decision, even though proceedings are still ongoing. It's incredibly convoluted, and we are really hoping that the Supreme Court sees the light. And with that, we'll open it up to some discussion. We'd love to hear from you all. First, what kind of challenges are you expecting to see? What kind of bad case law, or what kind of bases for denial, things that are going to make your life harder, do you think are going to come up before immigration court and the BIA? Alice, we'd love to hear from you.
Yeah, I mean, we support a lot of pro se litigants at CASA, so I mean, I am concerned about just, you know, their ability to be able to have any true opportunities for relief in the long run, right? And also, frankly, I'm a bit concerned about the potential weaponization of like E61s and E60s against counsel, right? Because we're required to basically document our support for pro se litigants, but the whole reason we're doing it pro se is because we don't have capacity to go in as deeply into like the record of proceedings or things like that. So I could see, I guess I'm more concerned about potential issues with the client being held against counsel even when we haven't entered an appearance. We have only done the E60 or E61, and then also thinking about like, yeah, best practices, like, you know, whether pro se litigants should, as a matter of course, like be advised to preserve their right to briefing and oral argument, or, I mean, clearly it's going to be their decision because they're pro se, right? But like, you know, that could be on the one hand, like if they preserve that and then they don't file a brief, then their appeal can be summarily dismissed. On the other hand, if they don't preserve it, right, based on the notice to appear alone, I'm not sure. It would have to be pretty egregious, the stuff that happened below, I would think, for the BIA to just remand based on only an NTA. An NOA. So those are some of the concerns that I have.
One of the increasingly concerning trends that I've been seeing in my cases is the IJs not holding the HS to their burden of proof. Cases where we deny that DHS has met their burden on alienage, and having an IJ say, well, it's not their burden of proof. So it's been very, very hard in those situations where the IJs get angry at at us for requesting something that is you know uh, a right to challenge, right? The other thing that I've seen is DHS not wanting to give us sometimes they don't present the now it escaped with me the name of the form that accompanies the NTA or with the description of the charges. You know what I'm saying.
The I-213.
I-213, thank you very much. The I-213, I request them and they say, oh, well, no, we are not FOIA officers. You go and submit a FOIA. Not even when we are before the IJ and we say, okay, I would like to see the I-213. Well, no, where there are where the whole charge, for example, is our client being a gang member. Okay, where did you get that from? And they do not present any evidence. So I've been seeing that more and more, and it's quite concerning. And it has led us to file a lot of motions to subpoena FOIAs, and and again, going to building that record, it requires a lot of work, but it requires us to do more and more due diligence and file FOIAs and FOIA appeals and then subpoenas, because it's becoming increasingly hard to build a case.
Are there other strategies people are thinking about to prepare that we haven't talked about yet today that could be helpful for others to start thinking about? Go ahead, Taylor.
Hi, everyone. I just put something in the chat too about a case matter of MAF that we're hearing of OPLA citing to a lot more. I think that we will hear more and more of that, particularly with all the folks who used notarios to fill out their I-589s. And the other thing that I'm seeing a lot of, and I'm suggesting to everyone, is seeing a lot of OPLA asking way more than they used to for chain of custody about the evidence. So just really reminding practitioners from the very beginning that you want to save envelopes, you want to save the whole history of how you got something. And to be fair, I think a lot of it is fair, because I do think there is a lot of fraudulent declarations and stuff getting written. And so what I suggest people to do is if you're trying to get a declaration from outside of the United States, or if they're scared to mail it, and you want to do it through WhatsApp or Telegram, etc., to have them write the affidavit, whether it's going to be written or going to be done some other way. And if it's going to be written, handwritten, or typed, and then have them sign it, and then take a picture of the affidavit, take a picture of them holding the affidavit with their ID, and take a picture of the ID, and have all of those sent directly to the attorney in WhatsApp or Telegram, and then include screenshots of that whole conversation as well, and file that. That's what lots of folks have been doing, particularly on the Russian cases, is where we're seeing most of the allegations. But yeah.
Hi, I'm sorry. Can you repeat that? You went a little too fast for me to take notes.
Sorry, just that I'm suggesting that if you're gonna get an affidavit from overseas and they say they're too scared to mail it,
Yeah.
to have them either type it or write it, but have them have it in paper on them. They take a picture and they
Mhm.
text it directly over WhatsApp or Telegram or probably not email because it shows the phone number, right? It shows it's a foreign
Right.
number, and they WhatsApp or Telegram it, etc. to you directly, not to the family, preferably. And then they also send a picture of them holding the physical piece of paper and preferably also holding their ID. So in one hand, they're holding the piece of paper,
Okay.
one hand, they're holding the ID. And they send you that picture in the same exact thread. And they send you a picture of their ID in the exact same thread. And then you file the affidavit, the picture of them holding the affidavit, and also the ID and the screenshot of the whole conversation. So you can
Okay.
prove chain of custody as opposed to your client's family just handing you, this is an affidavit from X country. And then in court, Opla's like, how'd you get it? And they're like, well, we got it. You know, that you have the whole history from the beginning. Lots and lots of IJs and Opla are wanting that in border detention centers already, that kind of chain of evidence.
Thank you.
Thank you, Taylor, for that really practical advice. And I know, again, we've gone over some basics sort of trial practice, but this is really how we're going to be able to fight person by person the next 4 years. That's where the battle's at. So yeah, hopefully we can keep sharing strategies. I know we're almost at time, so I just wanted to go over the resources. I'll be sending these over email. If you're not on the list, message me or email. I got several of you to send it over. Thank you. That ROP advisory, our PSG tracking sheet, which is a live resource where we're always adding new PSGs on that have been successful. A guide on appeal writing I'll be emailing out. And then our next roundtable will be February 6th. Stay tuned on the 2025 series. We're still figuring out if we're going to do kind of monthly or bi-monthly, just knowing how crazy things will get. So we'll let you know. But February 6th, first Thursday of the month. Thank you all so much for being here. We really, really appreciate your time. We had almost 100 people live, which just is such a testament to folks mobilizing, getting ready to fight. So thank you. Thank you to Sam and Laura for an excellent presentation.
Thanks so much. Take care.
Thank you.
Thanks, everyone.